Okay, this is going to be a bond motion in the matter of Jordyn Jones, that's Jordyn Jones. Indictment number 19CP 187761. Please forgive me, I didn't catch your name, sir.
My name is Clifford Hardwick, Young.
Mr. Hardwick, are you ready to proceed?
We are.
Okay. And Mr. Abadi?
Yes, Judge.
Is the state ready to proceed?
Yes, Judge.
Okay, Mr. Abadi, you can proceed when you're ready. Or, I'm sorry, Mr. Hardwick, I apologize.
Good morning, Judge. The considerations that are involved in the court's determination as to whether or not this young lady is entitled to a reasonable bond, we have a specific roadmap that has been afforded us based upon the case of Ayala versus State. The citation is 262 Georgia 704. This is the seminal case that sets forth the criteria to be utilized in determining whether or not we have presented a viable basis for the court's consideration for a reasonable bond. The court states, and this is very, very important, that unlike many other states, the presumption of innocence has always remained with the person accused of a capital offense, even during the trial. The most fundamental premise of our criminal justice system is that a person ought not be punished for a criminal offense until the state has demonstrated guilt beyond a reasonable doubt. Unless the right to bail before trial is preserved, the presumption of innocence secured by centuries of struggle would lose its meaning. The court goes on to state that the state has the burden of persuasion in convincing the court that a defendant is not entitled to pretrial release. In speaking with counsel early this morning, he indicated that it will be the state's position that my client is not entitled to a bond. This requirement that the court recognize throughout this process, the presumption of innocence, means that the state has the burden of proving by preponderance of the evidence that the trial court should deny bail, either to secure Ms. Jones's presence in court or to protect the community. Now, there are specific criteria that are set forth in the court's making that determination. First, is there any significant risk of Ms. Jones fleeing the jurisdiction of the court or failing to appear in court when the appropriate time for her to appear in court is required? Second, does she pose any significant threat or danger to any person, to the community, or to any property in the community? Third, does she pose a significant risk of committing a felony prior to trial? And lastly, does she pose a risk of intimidating any witnesses or otherwise obstructing the administration of justice? Now, what is our response to all four of those, of course, is that she satisfies the criteria in each one of those. What is her history? Let me tell you very briefly. This young lady, who is 21 years old, has no significant criminal history at all. She has a misdemeanor out of Michigan, which occurred about 6 months ago, for which she presently is on probation. No felonies, no prior arrests, aside from the misdemeanor to which I refer. She has been a full-time student for the last 4 years at Clark Atlanta University, a biology major, on track to graduate in December of 2020. She has ties to the community through her family. She has a family member who happens to be present today, who has resided in Atlanta since 2002 for the last 17 years. Her name is Yolanda Cal. There is nothing in her history that would in any way portend a conclusion that that would occur, and there is absolutely no reason that a reasonable bond should not be considered for her. I will be more than happy to address any other factors that the court may deem necessary following the state's presentation.
Mr. Robotti?
Yes, Judge.
Good morning. Mr. Hardwick is correct. The state's contention at this time is that the defendant is not a good risk for bond and is not a candidate for bond at this time for several reasons. And I will go over the IALA factors that Mr. Hardwick referenced earlier. The state feels that she is a significant risk of flight. The majority of her ties are, if not all of them, are out of Michigan, where her mother and father both reside. And I say that to your honor because it's the state's evidence that the state has become aware of that after Miss Jones participated in the murder of Miss Alexis Crawford, she had withdrawn from Clark Atlanta University and was planning on moving back up to Michigan. The Rubbermaid tote to a friend asking her to replace that tote so she could put her clothes from her home, and which she shared with the victim, in this case, to move back up to Michigan with her father. Her father was going to help her move. We would also contend that she's a significant risk of danger to the community, as well as committing felonies pending trial for multiple reasons. Not only the heinous nature of the crimes that she's alleged to have committed with her co-defendant, Mr. Brantley, but I would contend to the court that she's a significant risk of committing felonies due to the actions after the homicide, where she helped conceal the body of Miss Alexis Crawford and then move it to a park in DeKalb. She then, after that, it would be the state's contention, attempted to conceal evidence of the rape of Miss Crawford by her then boyfriend, by the defendant's then boyfriend, also co-defendant Mr. Brantley. And I would weave into that argument, Your Honor, that she is a risk of intimidating witnesses for that same reason, because there are many of the witnesses in this case will be family members of Miss Crawford, as they were the last people that she spoke to. And on her own volition, the defendant, Miss Jones, called family members of Miss Crawford and told them that there was no DNA found in the rape kit. Well, that is incredibly incorrect. The results of the rape kit indicate that Mr. Brantley's semen was found inside of Miss Crawford. So therefore, again, trying to conceal evidence of a rape and mislead witnesses who would be testifying in this case. Based upon all that, we would contend, Your Honor, the state that Miss Jones is not a candidate for bond and should remain in the custody of the Fulton County Sheriff's Department.
Thank you, Mr. Robotti. Mr. Herbert?
Your Honor, there are two or three things that counsel stated that are factually incorrect. First of all, the effort on the part of Ms. Jones's family to withdraw her from Clark Atlanta only occurred within the last 48 hours. So there was, in fact, no attempt following her arrest in this incident to do that, as counsel has stated. Secondly, she did not have any participatory involvement whatsoever other than a supportive role following the allegation of rape. She accompanied her roommate at the time, and spent however much time was necessary for her to be at Grady as she went through the rape kit scenario following that particular allegation. Obviously, this is not the time to present the case in chief. There are so many factors that are not readily apparent as it pertains to this young lady's innocence in this regard. And I strongly urge the court to focus upon not the statements of counsel, which at this point are merely statements and unsubstantiated, but as I outlined, the criteria that the Georgia Supreme Court has employed this court to use in determining whether or not a reasonable bond should be granted to her. She's entitled to it. I would respectfully submit that, as I articulated, the burden rests upon the state to persuade the Superior Court that the defendant is not entitled to a bond under these circumstances, means that the state has the burden of proving by preponderance of the evidence that that bond should be denied. That has not been done this morning. Thank you, Judge.
In many ways, I think Ms. Jones, on paper, would appear to be an appropriate candidate for bonds, given that she has attended college and otherwise been involved in a community and has minimal criminal background. But there are two things when I look at the IALA factors that give me a concern as to whether she would be an appropriate candidate for bond. And those two things are the fact that really her only significant tie to the city of Atlanta or to the state of Georgia is her attendance at Clark Atlanta University. And that, all things being equal, her real ties to the community are in the state of Michigan where her parents are. The second factor that I find persuasive regarding looking at the IALA factors is that one of the things the court is to consider is whether or not the accused, Ms. Jones, poses a significant risk of intimidating witnesses or otherwise obstructing the administration of justice. And in this particular instance, there has been a showing, I think, by the state that Ms. Jones, in being involved in what is alleged here, may in fact have engaged in the ultimate intimidation of witnesses by potentially, allegedly, attempting to silence the sexual assault victim who had made the report. But in addition to that, when you combine that with the fact that Ms. Jones has allegedly been in contact with people who would be witnesses in this case, in terms of the family of Ms. Crawford, the court is persuaded that there is a risk that Ms. Jones would not return to the jurisdiction for trial in this matter, and that she may pose a significant risk of intimidating witnesses or obstructing the administration of this case. And for those two reasons, I'm going to deny bond at this time.
Judge, that concludes my business. May I be excused?
Yes.